Weeks time granted for necessary compliance. 2 weeks time granted for necessary compliance.
Please.
Find the appeal.
Appeal memo for withdrawal of appeal is filed, which reads as hereunder. In light of the same, the appeal is dismissed as not pressed. There shall be refund of court fee as per applicable rules. You are the claimant, is it?
Yes. Yes.
You are satisfied or what?
I am not aware, my lord. Since
No, that's it. That's
File, my lord, application for enlargement of time. This is a land acquisition appeal.
just 1 minute. Yes.
The application for enlargement of time is filed. It's a land acquisition appeal. 2,90,000 is the court fee payable. And, for that, my lord, I sought for, my lord, 8 weeks time. My lord,
8 weeks time granted. Compliance with office objection
some of the cases, my lord,
and IA 1 of 23 is allowed. Commission is taken note that due to financial stringency, the appellant requires further time to pay court fee.
Lord, in some of the cases, my lord, this keeping open, my lord, this IA, my lord, the notice to respondent was ordered. That could be done, my lord, or else, my lord, I will.
Let us see.
Right.
Yes, next.
This, my lord, I would require, my lord, another 4 days.
Yes. Yes, yes.
My lord, this I would require, my lord, a week's time, my lord.
Weeks time granted
Wait.
for necessary compliance.
my lord, delay application has to be filed. I have mailed to the corporation, my lord.
Weeks time granted for necessary compliance. Weeks time granted for necessary compliance.
Weeks time granted, my lord. Just a types company.
The 7th time on the
Last week's time comply other.
ಏನಿದೆ ಉಳಿದಿರೋದೇನಿದೆ 22 9 to ಅಲ್ಲಿ ಪಾಸ್ ನೀವು ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ಮಾಡಿ ಪಾಸ್ ಇವೆಲ್ಲ ಸಣ್ಣ ಪುಟ್ಟ
ಇಲ್ಲ ಅದು ಫೈಲ್ ಇದು ಕಳಿಸಿ ಸರ್ ಅದು ಟೈಪಿಂಗ್ ಕೊಡಿ ಸರ್ ವೀಕ್ಸ್ ಟೈಮ್ ಗ್ರಾಂಟೆಡ್ ವಿತಿನ್ ನಾನು
ಆಯ್ತು ಎಷ್ಟಾಗುತ್ತೆ ಅದು ಬಾಕಿದ್ ಮಾಡಿ ವೆಲ್ಫೇರ್ ಸ್ಟಾಂಪ್ ಅದೆಲ್ಲ
ಅಲ್ಲ ಅದು ಮಾಡ್ತೀವಿ ಸರ್ ಅದು
ಎಷ್ಟಾಗುತ್ತೆ ಮಾಡಿ ನಾನು ಟೈಮ್ ಕೊಡ್ತೀನಿ
I have filed LR's application in this case. There is delay days mentioned madila anta aste ಇದೆ. 445 days delay is there.
ಆಯ್ತು ಅದು ಬರೀ weeks time granted.
Some urgency yesterday I have moved this matters. The bill is dismissed.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ಮಾಡ್ಬಿಟ್ಟು ಮೆನ್ಷನ್ ಮಾಡಿ
please much okay.
I have filed memo for return of LCR, PCR, first case is injury case, second one is death case.
Placing memo on Reliance, the trial court is directed to. Where is the TCR now?
TCR illé ಇದೆ ಸ್ವಾಮಿ
ಇಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ
ಅಲ್ಲಿ ಹಾ ಇದು 2017 ಮ್ಯಾಟ್ರ್ ಮಿಲಾಡ್.
Thanks, Kumar. The registry is directed to send the trial court records.
Immediately after.
Tribunal. To the
Tribunal.
tribunal, alva,
Ah.
to enable the
For
appellant
withdrawal of
to
amount.
withdraw the amount
Withdraw.
deposited as per the direction of this court.
ಹೌದು.
Lord,
And,
it also
after
directed
such
to return
withdrawal,
immediately after
trial
release.
court is directed to send back the TCS
Please.
to this court.
ಹೌದು.
ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ MFA ಕಮ್ಮಿನಾ ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಕೇಸ್ ಈ ನಡುವೆ?
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅದಾವ ಸ್ವಾಮಿ, ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇನ್ನು 2017 ಮ್ಯಾಟ್ರ ಹೇಳಿ ಸಾಕಾಯ್ತು ಸ್ವಾಮಿ. ಮೆಮೋನು ಕೊಟ್ಟು ಅಲ್ಲಿ ಕೆಳಗಡೆ ಪೋಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಡಿವಿಷನ್ ಬೆಂಚ್ ತುಂಬಾ ಅದಾವ ಸ್ವಾಮಿ,
ಕೊಟ್ಟಿದ್ದು ನಾವ್ ಯಾವ್ದು ಇಲ್ಲ ಅಂತ ಮಾಡಿಲ್ಲ.
ತುಂಬಾ ಅದಾವ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಇಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಹೊಸ ಮ್ಯಾಟ್ರ್
ನಾವ್ ಅಂದ್ಕೊಂಡಿದ್ದೆ ಡಿವಿಷನ್
ನಾವು ತಾವು ಕ್ರಿಮಿನಲ್ ತಗೊಳಕತ್ತಿದ್ರಿ, ಅದಕ್ಕೆ ನಾವು MFA ಗಳು ಜಾಸ್ತಿ ಮೂವ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಇದ್ದದ್ ಫ್ಯಾಕ್ಟ್ ಹೇಳ್ಬೇಕು.
ಅದಂತೂ ಒಳ್ಳೆ
ಹಾ,
ಕೆಲಸ ಆಯ್ತು.
ಅದಕ್ಕೆ ನಾವು ಮೂವ್ ಮಾಡ್ಲಿಲ್ಲ. ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್, ನ್ಯೂ ಮ್ಯಾಟರ್ಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿದ್ದು ಬರ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು ನೋಡ.
ಹಾ, ಇದು 17 ಮ್ಯಾಟರ್ ಮಿಲಾಡ್ ಅವಾಗ 2 ತಿಂಗಳು ಹಾಗೆ ಹಾಕಿದೀನಿ ಮೆಮೋ ಫಾರ್ ರಿಟರ್ನ್ ಅಪ್. ಒಂದ್ಸರಿ ಪೋಸ್ಟ್ ಆಯ್ತು, ರೀಚ್ ಆಗ್ಲಿಲ್ಲ. ಆಮೇಲೆ ತುಂಬಾ ಸರಿ ಹೇಳಿ ಸಾಕಾಗಿ ಲಾಸ್ಟ್ ದಿವಸ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ನಿನ್ನೆ ಮಾಡಿದ್ರೆ ಡಿಸ್ಪೋಸರ್ ಆಗ್ತಾ ಇತ್ತು ಸ್ವಾಮಿ.
ಅಲ್ಲ, ವಿ ವರ್ ಕಾನ್ಸಂಟ್ರೇಟಿಂಗ್ ಆನ್ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್.
ಹಾ, ಅದಕ್ಕೆ ನಾನು ಮೂವ್ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ನಾ ತೊಂದ್ರೆ ಕೊಡಬಾರ್ದು ಅಂತೇಳಿ ಅದಕ್ಕೆ ನಾ ಬಂದು ಮ್ಯಾಟರ್ ಸಿಂಗಲ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಇದಕ್ಕೆ ನಮ್ಗೆ
Yes.
The petition.
The statement of objection, second set has to be filed, my lord. It will be done within a week, my lord, today itself.
Week's time granted to file second set of objections. Second set of objections.
That is the.
Yes, next.
My lord, during the course, I'll do it, ma'am, please.
ಹಾ,
Pass over, ma'am, please. I'll do the during the
Pass
course
over.
because I said I moved the
ಆಯ್ತು, ಮಾಡಿ
and I served a notice on respondents, ma'am, please.
They were directed to comply the order dated.
My lord, here the letter was
12,
written to the
2024.
government, immediately after getting the funds, that will be paid, my lord.
It will be
Jilla
paid.
Panch, yes, my lord. Budget ಬರ್ಬೇಕು.
What was the direction?
Direction to pay the compensation of the land which was occurred for the purpose of formation of the road. Now, as per the direction of this honorable court, they surveyed, they got prepared the report, and now they have given the valuation also. So now they have accordingly passed the award and pay the compensation to the complainant.
India Act 1988, National Highway Authority of India was constituted. The object of authority is to develop, maintain and manage the national highways. The authority has taken the development of National Highway number 4 connecting to the Chennai to Mumbai as a part of development of National Highway number 4. The authority notifies the land survey number 94/1 measuring 4 guntas, survey number 84/2 measuring 1.5 guntas, and survey number 94/3 measuring half gunta situated in the Sempura village, Nelamangala Taluk, Bangalore district. An award came into past awarding the compensation of rupees 20,32,931 in respect of the lands and the buildings. In course of inquiry, the first respondent received claims and objections of the,
Paragraph 4.
please, my lords. It is necessary to extract section 3 clause H clause 4 of the act which is relevant for the purpose of this case. The same is as under. If any dispute arise as to the apportionment of the amount or any part thereof, or any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court or the original jurisdiction within the limits of those jurisdiction the land is situated. And next paragraph 5 minutes. The civil court passed impugned judgment on the reference made by the first respondent. The question thereof whether the judgment of the civil court on the reference under section 3 clause H clause 4 of the act is a decree within the meaning of clause 2 section 2 clause 2 of CPC and subsection 2 clause 2 of CPC read as under. The section 2 is been carved out, my lords. Para 6, my lords. With a reference is made under section 3 clause H clause 4 of the act. It partakes the nature of the suit. The civil suit is in the course of the adjudication of the legal rights of the parties in dispute has to adjudicate by applying the ordinary civil jurisdiction and rules of the civil procedure. The decree means in the formal expression of the adjudication by which the court conclusively and finally determines the right of the parties with regard to all or any matters in controversy in the suit. The civil court in the impugned judgment finally adjudicates the rights of the parties. Therefore, the impugned judgment is decree defined under section 2 clause 2 of CPC.
Next para you read.
Yes, my lords. The act do not provide any appeal against the judgment of civil court passed in a reference under section 3 clause H clause 4 of the act. Since the impugned judgment is a decree, the same is appealable under section 96 of the CPC. Then, my lords, a judgment is referred. Their writ petition had been filed, my lords, and writ petition was disposed of with the liberty to file an appeal, my lords.
Yes.
And corresponding, my lords, and a regular first appeal was filed before this honorable court, my lords.
Yes.
That judgment is also submitted before the honorable court for the reference, my lords.
But in this RFA, this question didn't arise.
No, my lords, since the matter was again remitted back, my lords.
The office, office has raised an objection as regards maintainability of the present appeal.
There, before the office, my lords, I have also submitted one of the order passed by the learned single judge as well, my lords.
Learned counsel appearing for the appellant Shri Narendra Reddy submits that the dispute amongst claimants regarding apportionment was a matter referred to the authority in terms of section 76
Yes, my lords.
of the National Highways Act.
No, my lords.
Of the,
Under the right to
of
fair
the
compensation.
Right to fair compensation and transparency in so and so act.
Please.
Further submitted that under section 3H4 of the National Highways Act provides for determination of such disputes by way of reference to resolution of dispute to the decision of principal civil court of original jurisdiction.
Yes, my lord.
Full stop. Next, it is submitted that an adjudication upon a reference under section 3H4 has the effect of adjudicating the rights, and order passed would be a decree under clause section 2(2) of CPC.
Please.
Reliance is placed on the order passed in WP 14374 of 2009. Next, taking note of observations made in WP 14374 of 2009 at paragraph 4 to 7.
4 to 7, my lords.
4 to 7. It is clear that the adjudication upon a reference under 3H4 by the court would result in adjudication of rights. An order passed would fall within section 2 subclause 2 of CPC and is a decree. If that were to be so, an appeal would be maintainable under section 96 of the CPC, though the National Highways Authority Act does not provide for any statutory appeal. Accordingly, office objection is overruled.
Please,
Yes.
my lords, one submission, my lords.
Huh.
My lords, this is dispute regarding the apportionment, my lords. Regarding the apportionment, my lords, and I have filed an application for stay also, my lords, and there is a delay of 16 days in preferring the appeal, my lords. Before the trial court, before the authority, my lords, an application was moved under order 41 rule 5 clause 2, my lords. Wherein, my lords, the stay is still operating till today, my lords. The same might be continued, my lords.
Where here you have stay you have obtained where?
Where before the authority, my lords. I have enclosed along with the stay application, my lords, at page number 75 is the order sheet, my lords.
So they've stayed it till appeal is.
Stay for a period of 3 months, my lords.
Uh-huh.
At the operative portion is at page number 96, 97, my lords.
The 3 months is still.
On the order is passed on 30th November 2024, my lords.
Uh,
It is still operating till as of now, my lords. Still 10 days are remaining.
So we will. So you want us to issue notice or what?
Issue notice, my lords, and stay could be consider the application for stay as well, my lords,
Taking note.
because the amount will be dispersed.
Taking note. But what is the dispute now?
Now dispute is that, my lords, I have been declared as the owner of the property, my lords, by virtue of a registered sale deed, my lords. My vendor had subsequently sold the plot, my lords, to the respondent number 4 vendor, my lords, and vendor has sold the site
That
to the
is a
respondent.
subsequent sale deed.
Subsequent sale deed, my lords, and by virtue of that, my lords, a decree is also passed to that effect, my lords. During pendency of the suit, my lords, I had filed a suit for declaration, injunction, and mandatory injunction, my lords.
Your suit is decreed.
My suit is decreed, my lords. That is placed before the authority, my lords.
You have made your vendor as a party.
Yes, my lords. All vendors were also made party, my lords. All this respondent is also made as a party, my lords, before the civil court, my lords.
Just show that.
Yes, my lords. During pendency of the suit, my lords.
Yes, show the judgment.
Yes, my lords.
The respondents herein are also party.
Yes.
Could.
During pendency of the suit, my lords, the property was acquired. As such, I was only declared as owner of the property, my lords.
So Gausia Begum is a party.
Yes, my lords. Gausia Begum is also party, my lords. In view of the fact, my lords, it was acquired during pendency of the
What is in dispute is survey number 29.
plot number 29, my lords.
Counsel for the appellant submits that as regards the legal rights to the property in plot number 29, suit for declaration filed by the appellant, wherein the fourth respondent was a party, has been decreed, and accordingly this court may consider grant of relief by allowing IA2 of 25. Peruse the order passed in OS 17 of 2015 in light of the contention of the appellant as noticed above. pending disposal of IA2 of 25. There would be the respondent number.
Respond number 4, my lords.
No, who's to be restrained?
Restrained, my lords. Now the civil
Amount?
court, the amount is deposited before the authority, my lords.
Before the authority.
Yes, my lords. Now if the respondent number 4 files an application for release of the amount, my lords, the authority could release, my lords. So the
amount in deposit before the court
yes, my lords, it is deposited before the court, my lords, as referred in the judgment itself.
is not to be disbursed till the next date.
Please, my lords.
This order is passed pending disposal of consideration of IA 1 of 25.
Please, my lords.
2 of 25. 2 of 25.
Condonation,
Condonation of delay application is IA number 1 of 2025, my lords. Delay of 16 days in filing the appeal.
yes.
The other judgment, my lords, about I have referred is another judgment of the 2023, my lords, regarding the apportionment, my lords.
What
Wherein
is it?
competent civil court has the jurisdiction to entertain the matter, my lords. Rendered by the Honorable Apex Court, my lords, in the year 2023.
It says that's a decree.
Yes, my lords.
Yes.
Please, oblige, my lords.
Yes, next. Huh? Issue notice to the respondent. AG is directed to accept notice for respondents. One emergent notice to the other respondents. ಅಲ್ಲಿ ಇಬ್ರು ಇರ್ಬೇಕು ನೋಡಿ, PWD ಇಬ್ರು ಇರ್ಬೇಕು ಅಥವಾ 3 ಜನ ಇರ್ಬೇಕು. 1 to 3 ಇರ್ಬೇಕು.
1 to 3 state government, my lords.
1 to 3. Now, National Highway, who appears?
National Highway, my lords, only National Highway is not a party, my lords.
3.
Yes, my lords.
Who will accept notice?
The government advocate could accept the notice, my lords.
National Highway.
National level ನಾವಿಲ್ಲ.
ಅದೇ ತೋರಿಸಿ. Just show him the cost rate.
Please, my lords. Respond number 1 and 2, government advocate can be directed to take
So
notice.
let them verify. They have some.
Please.
There is no standing counsel, is it?
Ms. Santosh Mardi, advocate, my lords. is a
ನ್ಯಾಷನಲ್
standing
ಹೈವೇ
counsel.
ಅಥಾರಿಟಿ ಅಂದ್ರೆ ಅವರು ಇದು ನ್ಯಾಷನಲ್ ಹೈವೇ ಸಬ್ ಡಿವಿಷನ್ ಇದಂದ್ರೆ ನಾವೇ ಬರ್ತೀವಿ. ಇಟ್ ಇಸ್ ಜಸ್ಟ್ ಮೆನ್ಷನ್ಡ್ ಆಸ್ ನ್ಯಾಷನಲ್ ಹೈವೇ. ಆಮೇಲೆ ನ್ಯಾಷನಲ್ ಹೈವೇ ಅಥಾರಿಟಿ ಅಂತಿದ್ರೆ ಅವ್ರು ಬೇರೆ ವಕೀಲ ಇರ್ತಾರೆ.
So we'll ask him to accept, then let us see.
Please, my lords.
Santosh,
Mardi, advocate.
directed to accept notice for respondents 1 to 3. Emergent notice to respondent number 4. ECR to be summoned forthwith.
Please.
Yes.
Oblige, my lords.
14.
I appear for the respondent. My lord, the appellant preferred this appeal being agreed by the order of the Honorable Learned Judge.
The office objection regarding furnishing of translated copy is kept in abeyance for the present. Yes.
This appeal is preferred being agreed by the order of the Learned Single Judge, my lord, wherein the Honorable Learned Single Judge was pleased to direct this appellant to pay substantial allowances to the respondent number 4.
The respondent number
4, my lord. The respondent number 4 is an employee working under this appellant.
he was placed under suspension. Huh?
Suspension.
Ah.
He was working under this appellant, my lord, and he has committed a murder of his wife. This fact was known to the respondent number 2, division DDPI. DDPI wrote a letter to this appellant. Your employee is in judicial custody. Take necessary action and intimate the same as per annexure R1, my lord. And the society has taken this R2. This appellant has taken passed an order keeping him in suspension from the date of arrest, that is 24/4/2011. When he was in judicial custody in jail, he made an application to give substances allowances. For that only, for that also, this appellant wrote a letter to the respondent number to DDP. So and so respondent number 4 is in judicial custody and he has made an application to this appellant for needful action you have to intimate ಅಂತ ಅವ್ರಿಗೆ ಕೇಳೋದಾಯ್ತು. ಕೇಳಿದ ತಕ್ಷಣ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು, as per
No, now you represent whom?
I am representing society, appellant my lord.
Now he is an employee of?
Our employee.
Aito. Now who is to pay? You have to pay.
No, my lord.
Tell us.
Because as per R1, because the reason is that society is aided society. Aided society, my lord. Aided society ಇದ್ದಾಗ ಅವ್ರು ಏನದ DDP ನಮಗೆ ಲೆಟರ್ ಬರ್ದ್ರು, ನಿಮ್ಮ ಎಂಪ್ಲಾಯ್ ಏನದ ಮರ್ಡರ್ ಕೇಸ್ ನಲ್ಲಿ ಜೆಸಿ ನಲ್ಲಿ ಅದನ್ನ ಅವನ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡು ಇಂಟಿಮೇಷನ್ ಮಾಡ್ರಿ ಅಂತ. ಅವ್ರ ಲೆಟರ್ ಪ್ರಕಾರ ನಾವೇನದ ಅವನಿಗೆ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿ DDPಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೇವೆ ಆಸ್ ಪರ್ R2 ಮೇಲೆ. R1 ಪ್ರಕಾರ ಅವ್ರ ಲೆಟರ್ annexure R1 page number 59 my lord.
Page
59 in page 59.
Now this post is admitted to grant in aid.
Yes my lord. ಅದಕ್ಕೆ ನಾವೇನು 59 ಆತ ಅವರೇ ಲೆಟರ್ ನಮಗೆ ಇಶ್ಯೂ ಮಾಡಿದ್ರು my lord.
That's okay. Now whoever is the government will have to pay.
ನಾನು ಅದೇ ನನ್ನದು ಬಟ್ ನಮ್ಮ
What does the single judge hold?
Single judge is hold, nothing has been elicited as against this appellant. Only in last para we are passing the liability from one person to another person. Therefore the respondent number 2 has to pay ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಮೇಲೆ. ನಾನು ಡಿಟೇಲ್ ಆಗಿ ಬರ್ದದ್ದು ಈವನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ. ಅವ್ರ ಗೌರ್ಮೆಂಟ್ ದವರೇ ನಮ್ಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರ ಆರ್ಡರ್ ಪ್ರಕಾರ ನಾವು
government you sit with the appellant and sort it out. Now, suppose it's admitted to grant in aid the post, then all payment is done by you, isn't it? So you sort it out with him. We'll have it next. You sit and sort it out.
Yes, I'll take notice and
AG accepts notice for the
2 and 3.
for respondent 2 and 1 to 3.
1 to 3, madam. 1
to 3. So and so.
respondent number 4 caveators notice served.
You're on caveat.
Please. Notice served.
Caveat has been filed as regards R4. Full stop. The AGA to make attempts to sort out the issue of liability and payment to respondent number 4 by the next date.
Till that manner. Interim stay may be
I
granted.
filed the contempt.
And also they have filed contempt as against
It
me.
may be clubbed along with.
So and so respondent number 4 undertakes not to precipitate contempt matters till the next date.
It may be clubbed along with.
Relist the matter on
after 2 weeks.
Put it on 18th.
Please.
Alright, I'll give the contempt number. It may be clubbed along with the contempt.
Code number. Contempt to 25.
Sir.
24
Yes.
or 25.
25.
See.
In this case, during pendency of appeal, my lord, the respondent is died. I have made an application for bringing LRs on record. The same is pending dispose.
Notice must go.
ನೋಟಿಸ್ ಅವ್ರಿಗೆ ಆಗಿದೆ ಅದರ್ ಸೈಡ್ ಮಾಂತೇಶ್ ಪಾಟೀಲ್ ಅವರು ಅಪೇರ್ ಆಗಿ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೇವೆ ಮೇಲೆ ಬಟ್ ಅವರು ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತಂದ್ರಿ
ಅದು ಬಂದ್ರೆ ಪಾಸ್ ಓವರ್. ಎಸ್ yes
Payment appeal.
counsel. So the appellant is filed. But why withdrawal? Any difficulty?
Lord, I have been instructed that, my lord, my counterpart is about to file review. In connected notification, review has been entertained, it seems,
Memo for withdrawal is filed. Which
in
reads as
before the LSC itself.
same order, isn't it?
Same,
That
same.
Previous matter.
Yes, my lord.
Which is that serial number?
Serial number 2, my lord.
Same order. No, but we have to reserve liberty or what now?
Yes.
Huh?
Yes, my lord. We have,
The,
yes, my lord. Liberty has to be reserved.
huh?
Yes, my lord.
In light of, it is further clarified, all contentions against the impugned order are kept open. Huh?
Yes. I have sought for refund of the court fee as well.
Yes, yes, yes. No, but you could have stated one extra sentence that you intend to file a review. Otherwise,
Yes.
Tengli next round will come and stoutly object.
The connected matters.
That are barred by order 2, rule 2, constructive restitution without liberty. No, I'm saying,
Yes, yes, yes.
if you are clear that you intend to seek for review,
Yes.
you can add one sentence, you find out.
Yes.
Before signing the order, if you have instructions, make a mention.
Liberty may be granted, my lord. Oral request may be recorded. Liberty may be granted. Since, my lord, otherwise.
Is reserved to raise contentions against the impugned order if circumstances are so made out subsequent.
In serial number 2 as well.
Yeah. Other lowest, 2 lowest.
Oh, bless. Oh, bless.
Relist the matter, date good. Relist the matter. Same one.
But another connected appeal is there, kindly post along.
List along with MFA number so and so on date good.
They could be condemned.
The lands were acquired for Chimbalgi lift irrigation, my lord, there is a delay. My lord, the reference court has awarded 3,404 per gunta, which was enhanced to 32,063 per gunta. There was an exorbitant announcement is there, my lord, it is filed. Since there is a delay, 187 days,
So how much will deposit?
52.
50% not in similar matters.
50%.
Yes. And it is permitted to be withdrawn.
That same, some standard order is there.
Yes,
isn't it?
there is one similar order.
The IA 1 of 23 is allowed. Delay in filing the appeal is condoned accepting the cause shown. Insofar as, in light of the contentions raised, there will be stay of the judgment and award of the reference court,
Yes.
subject to deposit of 50% of the
Award amount, my lord.
award amount. Upon such deposit, the claimant respondents are at liberty to withdraw the same upon executing an indemnity bond and filing an undertaking, agreeing to pay the amount along with current bank interest. Needless to state, the withdrawal would be subject to orders to be passed in the appeal. Anybody else, or the service is complete?
Yes.
PCR to be summoned.
It,
I think condone ಮಾಡಿ.
it will be authority under the new act, my lord. Reference court under the old act.
Reference court
In the new act, it is authority.
authority under section 64.
Yes, ma'am. The
Huh?
reference under 64. Deposit may be made before the authority itself.
The deposit of the deposit is directed to be made before the authority. No, but that authority is a court, no?
Yes, yes, it's a court. It's
It's a
under
court.
the act, my lord, it's designated as an authority.
It's 187 days delay.
Yes. Same.
Same.
Huh?
Same.
Now this, we don't have to make any reference regarding 187 days. Anyhow, that's a legal position, isn't it? Otherwise, we have to keep it open, no?
Please.
IA 1 of 23 is kept open. As it is noticed that question of condonation of delay beyond 120 days is still pending consideration before the apex court. Pending consideration of IA 1 of 23, there would be stay of the judgment and award of the competent authority, subject to the appellant depositing 50% of the amount awarded within a period of
8 weeks.
8 weeks, merely 8 weeks.
8 weeks.
Upon such deposit, claimants are entitled to withdraw the same order. This emergent notice, PCR to be summoned. Yes, next.
Delay of 6 days in filing appeal.
Yes.
IA 1 for 6 days delay in filing appeal.
Delay may be controlled.
IA 1 of 2024 is allowed. Delay in filing the appeal is condoned excepting cause shown. What is IA 2 of 24?
2 for stay petition, my lord.
For
Judgment and decree of the trial court be stay
partition.
partitions.
Next week, your lord, for admission, but I have not gone through the. Next week, your lordship may posted for admission.
This is the matter for admission
And
on
also call for LCR, my lord.
PCR to be summoned.
Yes, please.
Relist the matter. Yes, next. Huh?
There is a delay
Issue notice.
of 632. Notice has been issued, your lordships.
Have they filed objections?
No, your lordships, they have not yet filed objections.
Not yet.
Not yet filed objections.
Let us see. We'll fix a date.
Please, your lordships.
Objections, if any, to be filed to IA 1 of 24. Relist the matter on.
Please.
There is a delay of 75 days.
Issue notice on IA as well as main. Government appears, is it?
No, my lord. Veeranagowda Mali Patil.
Huh?
Veeranagowda Mali Patil. Hatti Cooperative Society.
Is so and so is directed to accept notice for
2 to 4.
2 to 4.
2 to 3.
2 to
3.
2 to 3. 2 and 3. What about 4? Emergent notice to 4. Central Government Standing Council is directed to accept notice for 1.
Please.
Yes.
Central government.
Sudhir Singh
Sudhir Singh.
is directed to accept notice for. Adralli. Yes, next. You are not a party, is it?
He was party, my lord, but he died during the pendency of the suit. And he died, my lord, on 21/2/2023.
No, you are the defendant.
I am defendant, my lord. Appeal is filed by defendant number 2, 3 and 5, sir. So their addresses are wrongly shown. And to establish that fact, my lord.
To notice on IA 1 of 24. Yes.
Sought for interim stay, my lord.
No, let us see. It's a nullity only. You serve it, let it come, we'll see.
Or they have filed FDP, my lord. If they,
The appellant is permitted
only not to
serve.
draw the decree, my lord.
Appellant is permitted to serve copy of notice on counsel appearing for the respondents in the FDP proceedings.
Please stop this.
Relist the matter on.
Your Lordships, this is the first appeal against the judgment and decree passed in OS number 214 of 2006, dated 18/4/2009, Your Lordships. There's a delay of 4,916 days and the
Let's see, it has some-
respondents have to file.
Correct.
I have moved the memo because EP is pending, Your Lordships. Let the proceedings in EP be stalled till the delay is condoned or stay orders granted by this court. It is
So what
EP
is the-
88 of 2016 is
What is
pending,
the decree now?
pending before the court, Your Lordships.
No, what was the
The
judgment
The
you
suit of the
suffered?
plaintiff is decreed with cost. It is declared that the plaintiffs are the joint owners of the suit land bearing survey number 11 measuring 8 acres, 8 guntas, and for decree of recovery of possession of the suit land in the event of first defendant not initiating proceedings for acquisition of the suit land to determine the market value and to pay compensation to the plaintiffs 3 months from this judgment and decree. Further, the plaintiffs are entitled for correction of the entries in the RORs. Your Lordships, the area which has been said to be acquired is the buffer zone, Your Lordships. 1 acre, 21 guntas of land. There was already an existing jail. In BZ jail was in existence, and the 90 meters radius is considered as a buffer zone. And at the time of granting of any order for converting the land into residential purpose, there was a condition precedent saying that they will never claim ownership for that 90 meters of buffer zone area, Your Lordships, in the order of the Deputy Commissioner dated 1970, which remained unchallenged till this day, till the filing of the suit. Now they say that they are the owners of the land and they want compensation or to acquire this land and pay compensation or to deliver the possession.
The condition, let's have a look.
Your Lordships, exhibit P, and I think whether the records are there. I've got a DC's order, Your Lordships. Yeah, pass on.
Where is the condition imposed?
The next page, Your Lordships, I put them.
But why did you keep quiet for
Your Lordships,
5,000 days?
yes.
More than 10 years. Huh?
Let any orders be passed on delay, but till then not to pass any orders and execute. Let the.
Okay, we want to know
Yes, Your Lordships.
why there is so much delay.
Administrative exigencies, Your Lordships.
Not
Because, and secondly.
No, you must say boldly collusion, one.
No,
Two.
No, may I make a fair, yes, I will reveal the truth. What happened is the Assistant Commissioner Bida was made the litigation conducting officer. The people from the jail authorities, they gave all the documents to the Assistant Commissioner Baswa Kalyan, as he was the litigation conducting officer. He never forwarded the same to the Advocate General's office. Only when they came to know, they have approved. That was a delay for 4 years. 2020 is the GO issue. I cannot pray for stay also because there is a delay. Stay cannot be granted unless the delay is condoned.
Correct, but to show your bona fides, you must institute a departmental inquiry of proceedings to ask them, you explain the delay, which may help you on merits later. At least to demonstrate your bona fides,
please,
you must direct an inquiry to be held. Why it was not followed?
Please, Your Lordship, I will that recommendation I will make it to the government to make an inquiry as to why there was this delay.
Pending here, consideration of IA 1 of 24, taking note of the submission that in the order of conversion by the Deputy Commissioner dated 28/2/1970 at condition number 2, it was specifically provided that insofar as 90 feet space around the jail building, same would be left vacant for all time. There would be an order not to precipitate the execution proceedings till the next date.
Oh, obliged.
But you must demonstrate.
No, I will demonstrate, Your Lordship.
Bona fides immediately.
Please, Your Lordship, that I will write it to the. Highly obliged.
Sir, I appear for appellants in the case. Accused number 3 and 4 are before this honorable court seeking suspension of sentence and bail. Delay of 87 days was condoned by the honorable court on last date of hearing. And 3 and 4, they were charged along with the 302 and 307. They were even charged for 114 of IPC, sir. That is, they were present on the spot at the time of offense. But that is, I am not found guilty for 114 in the judgment passed by the trial court. I am acquitted for the same, sir. I am convicted and sentenced for the offense punishable under section 302 of IPC, life imprisonment along with fine. My role as per the charge sheet and the evidence is that I have abated accused number 1 and 2 to do away with the life of the deceased. That was the case, and I was on bail during the course of trial and never misused the liberty. And post sentence, I am 6 months serving in Central Prison, Kalaburagi. Post sentence 3 and 4, sir.
What is the evidence of 1 and 6 eyewitness?
Sir,
Evidence of PW 1 and 6 eyewitness.
Eyewitness, they state that there was previous enmity between both the parties. They happen to be relatives. Enmity in connection with illicit affair with one of the relatives, and enmity was also there in connection with the cartway which passes through the land of these petitioners. And hence,
Any overtake against you?
please, overtact is they were standing there and instigating A1 and A2 anteli helar, sir.
That is there in the page. I'm filing objection. In page number 76, Millers, in judgment, trial court judgment, the role of accused number 3 and 4. The accused number 4 is the elder brother of the accused number 1. Accused number 4 is the elder brother of the accused number 2. Accused number 1. The accused number 3 is the younger brother of the accused number 2. They all happens to be from same family, and they had an intention to kill. Of course, my lords, there is a even as per the Honorable Apex Court, my lords, the
There is no such overt act. A1 and A2 assaulted.
assaulted,
Hmm.
and they too were very much present at the time of crime, my lords.
Hmm.
And
Present and instigated. Huh?
and yet instigated, and they were watching at the time of incident, my lords.
Is it sufficient to attract 34? 34 Bharata.
Common intention, definitely it comes, my lords.
Hmm. So to establish mere presence.
After meticulously,
Not mere presence. Just
mere
use of
presence in
act.
the, yes, my lords, I do
Specific
agree.
act.
But mere presence in the sense, my lords, they were watching the persons if somebody coming over there and all those things. And also in the evidence of PW 1 and 6, it has come that, my lords, they all prepared for this crime. And they are the persons who instigated them to take the deadly weapons. That accused number 2 club and 2 has taken.
Order on IA number. IA 2, huh?
IA 2, sir.
IA number 2 of 2025. This application filed under section 430 subclause 1 of BNSS 2023 to suspend the sentence for grant of bail. The applicants are the appellants in the main appeal have challenged the judgment, conviction and order of sentence passed in SC number 188.
188 of 22.
22, dated challenge the judgment of conviction and order of sentence dated April 1st degree, dated 5th September 2024. In SC number 188 of 2022 by the first additional district and session judge at Kalaburagi, whereby the learned session judge has stated these appellants, who are arrayed as accused number 2 and 3, along with the 2 others, that is accused number 1 and 2, for the offence punishable under section 302 and 307 that with 34 of IPC, and sentence them to undergo imprisonment for life and to pay a fine of rupees 50,000 each in default, to undergo SI for 6 months for the offence 302 that with 34 IPC. Further, sentenced to undergo rigorous imprisonment for 5 years and to pay fine of rupees 25,000 for the offence 25,000 in default, undergo simple imprisonment for 1 month for the offence 307 of IPC. Full stop. The IPC. The summary of the prosecution case is that on 11/4/2022 at about 2:30 AM, the appellants along with the 2 others came to the land, visited the land of CW 19, and thereby assaulted the deceased, in this case one Basavaraju, thereby accused number 1 and 2 were assaulted the deceased Basavaraju with the Basavaraju with the deadly weapons, full stop. At that time, these appellants, that is accused number 3 and 4, were present in the scene of occurrence and abated the accused number 1 and 2 to commit the murder of a deceased Basavaraju. Full stop. As such, full stop. Accordingly, a charge sheet has been laid against these appellants for the aforesaid offences by arraying them as accused number 3 and 4. Full stop. After a detailed trial before the learned session judge in SC number 188 of 22, the learned session judge convicted these appellants along with the 2 others and sentenced them as stated supra. Full stop. So we have heard the learned counsel for the appellant, so also the learned additional SPP. Full stop. The primary contention of the learned counsel for the appellant that these 2 appellants the appellants being accused number 3 and 4, the 3 and 4, the only allegation against them that they were present at the scene of occurrence without any such a specific, without any such act, any such act committed by them. Full stop. Committed by them. Full stop. As such, initially they were charged for the offence 114 of IPC. Full stop. Further, the eyewitness PW1 and PW6 also stated that the accused neither assaulted the deceased nor instigated accused number 1 and 6, while accused number 1 and 2, except their presence in the scene of occurrence, there is no such overt act against them. In such circumstance, the conviction against them, conviction passed against them by invoking section 34 of IPC is misconceived by the learned session judge. Full stop. Per contra, the learned additional SPP would submit that the learned session judge, after examining the evidence, more particularly the evidence of PW 1 and 6, the eyewitness, passed a well-reasoned judgment. Well-reasoned judgment, full stop. According to him, these accused being the brothers of the accused number 1 and 2 has shared the common intention to do away the life of a deceased. In such circumstance, the session judge rightly invoked section 34 and convicted these accused for the offence they have charged. Accordingly, he prays to dismiss the application. We have carefully examined. We have given our anxious consideration both on the submission, both on the arguments advanced by learned counsels. So also perused the impugned judgment. Full stop. As could be seen from the impugned judgment, admittedly these appellants being the accused number 3 and 4, except their presence in the scene of occurrence, there is no such specific overt act as attributed against them on perusal of the evidence of the material witness, that is eyewitness PW 1 and 6. Though the session judge has convicted them session judge has convicted based on the placing reliance of the evidence of PW 1 and 6, the same 1 and 6, since 1 and 6, since both those witnesses were not deposed any specific overt act against these petitioner, these appellants, without expressing any opinion on the merits of the case, considering the aspect that these appellants were on bail during the course of trial and there is no such complaints regarding the misuse of the liberty granted to them during the course of trial. So also considering the aspect that this appeal is of the year 2025, there is no such possibility of hearing this appeal immediately in near future, placing reliance on the judgment of the Honorable Apex Court in the case of Kashmir Singh versus State of Punjab, report in 1977, we are of the view that the IA number 2 of 2025 may be considered by imposing conditions. Accordingly, IA 2 of 25 allowed, subject to the condition that the appellant shall execute a personal bond for a sum of rupees 1 lakh each with the two sureties for the satisfaction of the trial court. Further, they shall deposit the entire fine amount before the trial court. First, next, third, admit. Registry is directed to secure the trial court records and to file the paper books within paper books. List this appeal in the usual course for hearing.
Obliged.
Apologize, my lord, 28 matter I was another court.
Till the next date, you have said, we have not disposed the IA, we have kept it pending.
Objections were ready.
And so we have kept it pending.
Obliged. Obliged.
Lord, I'm serving as Deputy Director, my Lord, of Employee State Insurance Corporation. Lord, there was an allegation, my Lord, there is irregularity and illegality in the process of tender. A complaint was made by one of the participants because I was the part of, my Lord, tender accepting authority. My Lord, inquiry was conducted, my Lord, a punitive order was passed, holding that, my Lord, this thing should be reduced by 5 years. I approached the Central Administrative Tribunal. The CAT came to a firm conclusion, my Lord, that there is no malafide. Maybe because of ignorance, certain things would have happened. That order was set aside, and my Lord, there was a specific direction that the authorities, my Lord, should decide the matter within a period of 8 weeks. This order is passed, my Lord, way back in the year 2023, July. Yet, my Lord, despite filing of the contempt, my Lord, no steps are being taken, my Lord, by the respondent to adjudicate the matter. In the meanwhile, Lord, promotion orders are, my Lord, passed, promoting all the officers who are, my Lord, way below junior to me, who are being, my Lord, now promoted as joint directors. And, my Lord, my case is kept pending merely because, my Lord, that direction, my Lord, of the CAT is yet to be complied. My Lord, I have produced the copy of the order of, my Lord, my juniors being promoted.
No, correct. Now you take instructions. Meanwhile, if the matter is remitted back, if there is no inquiry pending,
please,
to what stage it is remitted back?
My Lord, it is remitted back, my Lord. I will, my Lord, I read the operative portion, relevant portion, my Lord. It starts, my Lord, at page number 35.
20?
Page number 35, my Lord, is the order holding that, my Lord, the punishment is in excess. Page number 35 and 36.
No,
Order,
no, it's
operative portion, my Lord, is that it starts at page number 37. And, my Lord, the more relevant portion, my Lord, is at page number 38.
That's correct. Now it is sent back to which stage?
Disciplinary authority shall reconsider the matter and pass appropriate orders in accordance with law and expedite the matter in any event less than 8 weeks.
So the charges still remain, is it?
Charges remain, my Lord.
Can you get instruction?
No, my respectful submission, my Lord. Otherwise, my Lord.
No, no, correct. Now it will have to be decided. But now you find out how much time you do. You have to conclude that whatever proceeding. Correct. So by the next day, with respect to the direction at serial number 3, you have to find out and make submission.
One submission, if I may, my Lord. The observation, my Lord, by the CAT is that, my Lord, it may be a case, my Lord, of negligence, but not of malafides. So my respectful submission, if, my Lord, otherwise, my Lord, I am entitled for promotion, since they have not decided for more than almost 2 years now. My Lord, without prejudice, my Lord, to the pending inquiry, let them promote me, my Lord, which will be subject to, my Lord, the result of the action being taken by.
Get instructions. Is to take instructions regarding the specific assertion of counsel for the petitioner that the direction at serial number 3 of the order in OA 170, a number is there, page 38 will mail OA number, so and so, has not been complied with. DSGI accepts notice for respondent number 1 and 2. Relist the matter on week after next date.
Obliged.
Under the pressure. Charge may have to.
Your Lordship, sir, affidavit is filed, Your Lordship.
Yes.
As per the decision of the learned single judge, speaking orders passed and subsequently.
Just have a look at our order last time. What?
Please.
Just read that order.
The may be permitted. The audacity of the accused.
Just read the last time's order. 20th February. 20th February.
Please, Your Lordship.
Online order कहाँ है?
इसमें देखो। Please.
Just read it aloud. Read it aloud.
The name of the complaint, the list of the.
Read it aloud.
Louder.
Read it aloud.
May I read? Reading to the same would reveal that the proposal has been made to include the name of the complainant in the list of government and necessary permission of the government in that regard has been sought.
Where are you reading? Order dated.
Page number 3, order.
No, read
Oral
from the
order.
beginning.
May I read it from the beginning? Okay. We are prima facie not satisfied with the explanation made by the accused. Peruse the order dated 18/7/2024, passed in WP number 201810 of 2022. A detailed orders passed by the learned single judge with the direction to the additional commissioner for public instructions to consider the letter dated 12/6/2020 and pass appropriate orders in accordance with law within a period of 4 weeks. The letter dated 12/6/2020 is a communication addressed by the Deputy Director of Public Instructions, Kalaburagi, to the Additional Commissioner for Public Instructions, Kalaburagi. The said document is self-explanatory and reads as under. You can read the Kannada portion. Your Lordships, my AG will read the Kannada portion.
ಮಾನ್ಯ ಅಪರ ಆಯುಕ್ತರು ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಮಾನ್ಯರೇ, ವಿಷಯ ಶ್ರೀ ರವೀಂದ್ರ ತಂದೆ ಮಹಾಂತಪ್ಪ ಸೇವಕ ಸೇಠ್ ಗೋವರ್ಧನ ಲಾಲ್ ವರ್ಮಾ ಹಿಂದಿ ಪ್ರೌಢಶಾಲೆ ಶಹಾಬಾದ್ ಚಿತಾಪುರ್ ಇವರ ಹುದ್ದೆ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಕುರಿತು ಉಲ್ಲೇಖ 1. ಈ ಕಚೇರಿ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ, ತಮ್ಮ ಕಚೇರಿ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ. ಈ ಕಚೇರಿಯಿಂದ ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳಿಗೆ ಬರೆದ ಪತ್ರ ದಿನಾಂಕ 31/12/2019, 24/2/2020. ಉಲ್ಲೇಖ 4. ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳು ಚಿತಾಪುರ ಅವರ ಪತ್ರ ದಿನಾಂಕ 6/3/2020. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಮೂಲಕ ಶ್ರೀ ರವೀಂದ್ರ ತಂದೆ ಮಹಾಂತಪ್ಪ ಸೇವಕ ಸೇಠ್ ಗೋವರ್ಧನ್ ಲಾಲ್ ವರ್ಮಾ ಹಿಂದಿ ಪ್ರೌಢಶಾಲೆ ಶಹಾಬಾದ್ ಚಿತಾಪುರ್ ಇವರ ಹುದ್ದೆ ವೇತನಾನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ್ದು ಉಲ್ಲೇಖ 2ರ ಮೂಲಕ ಮಾನ್ಯರು ಸದರಿ ಸೇವಕರ ಹುದ್ದೆ ವೇತನಾನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ 7 ಅಂಶಗಳ ಅಗತ್ಯ ದಾಖಲೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿ ಪ್ರಸ್ತಾವನೆ ಹಿಂದಿರುಗಿಸಿದ್ದು ಇರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಉಲ್ಲೇಖ 2, 3 ರನ್ವಯ ಶಿಕ್ಷಣಾಧಿಕಾರಿ ಚಿತ್ತಾಪುರ ಅವರಿಗೆ 7 ಅಂಶಗಳ ಅಗತ್ಯ ದಾಖಲೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿದ್ದು ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳು ಚಿತ್ತಾಪುರ ಅವರು ಉಲ್ಲೇಖ 4ರ ಮೂಲಕ ಸದರಿ 7 ಅಂಶಗಳ ಅಗತ್ಯ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ ಶ್ರೀ ರವೀಂದ್ರ ತಂದೆ ಮಾಂತಪ್ಪ ಸೇವಕ್ ಸೇಠ್ ಗವರ್ನರ್ಲಾಲ್ ವರ್ಮಾ ಹಿಂದಿ ಪ್ರೌಢಶಾಲೆ ಶಾಬಾದ್ ಚಿತ್ತಾಪುರ ಇವರು ಸದರಿ ಶಾಲೆಯಲ್ಲಿ 2ನೇ ಗ್ರೂಪ್ ಡಿ ಹುದ್ದೆ ಮೇಲೆ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಸದರಿ ನೌಕರ ಹೆಸರು ಸರ್ಕಾರದ ಆದೇಶದ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರ್ಪಡೆಗೊಳ್ಳಲು ಸರ್ಕಾರದ ಅನುಮತಿಗಾಗಿ ಮತ್ತು ಆದೇಶಕ್ಕಾಗಿ ಸದರಿ 7 ಅಂಶಗಳನ್ನೊಳಗೊಂಡ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದೆ. ಅಡಕ ಪ್ರಸ್ತಾವನೆ. Reading of the same would reveal that proposal has been made to include name of the complainant in the list of government and necessary permission of the government in that regard has been sought. It must be noticed that the complainant had on an earlier occasion filed WP number so and so seeking for a direction to consider passing of appropriate orders under section 131 of Karnataka Education Act. Subsequently, after the disposal of the writ petition, the proceedings under section 131 came to be disposed of as per the order dated 15/10/2018. The order passed on 15/10/2018 setting out all the aspects of the matter, including regarding admitting of post to grant in aid with respect to of D group apart from 1 group D post. It is case put forth by the accused that if the proposal was sent in time, the same could have been considered, and in light of the ban operating from 10/6/2020, the question of now considering the proposal does not arise. It must be noticed that the entirety of the case of the petitioner was that he has been making several representations and on private educational institution had not taken any action to send his name despite his entitlement. It is the further case that once the court had passed an order, the consideration of including his name in the list ought to date back to his legal entitlement at an earlier point of time and cannot now be defeated on the sole ground that as on date there is a bar for such consideration of admitting the post to grant in aid. The order of the land single judge is a well considered order and a direction has been passed. The defense now set up cannot have the effect of defeating the right of the petitioner whose name was not forwarded for no fault of his. Accordingly, we find that the stand of the respondent accused in multiple affidavits cannot be accepted. Hence, leave this matter for framing of the charges on so and so day.
The only one thing is one document has been produced as per the present affidavit, Your Lordships.
Just one.
Yesterday's, yes.
Madam, file thought.
Madam.
Yes.
Wherein all the list has been produced, Your Lordship, Annexure R4. All those who have been eligible and the applicant stands at serial number 149 in seniority, Your Lordships. It's from 1964.
No, but we have heard on framing of charge, so nothing further remains. It's there for framing of charge. We have heard on the proposed defense and we have considered it.
This document was not filed earlier, Your Lordships.
Yeah?
Seniority list document was not filed. He stands at Annexure R4, yesterday's affidavit.
And make one submission, my lord.
With regard to
They are
seniority of.
reiterating what
all.
has been said earlier.
Just wait.
Because I'm not. It's with regard to 376. SDA's, yesterday's the document, yesterday's affidavit, Your Lordships.
Annexure are?
R4, Your Lordships.
No,
Page
but,
number, in page number 19, Your Lordships.
but the more you draw us in, there's more trouble for him. I'm warning you now itself. The more you are going to draw us in, the more we are inclined to make it harder for you to get out of it. We're given an opportunity to purge. Yes, R4. The more you draw us in, more observation will make. I'm putting you to notice on that. You want us to go further, we will go. You want to make compliance, final opportunity is there. I'll pass over, you come back.
Please, Your Lordships.
If any wavering, we will proceed further. We have
Please,
made
Your
up our mind.
Kindly be passed over, Your Lordships.
Pass on.
Obliged.
Oblige.
Yes.
I prefer appellant.
Yes.
My lord, appeal prepared by the insurance company, my lord, challenging the liability. My lord, I sought first time, my lord, 50% I will deposit. My lord, in so for liability concern, my lord, at the time of accident, my lord, there is no policy. Coverage is not there. The policy was expired. Here, two vehicles are there, two insurance companies are there. One vehicle, 70% fixed, liability fixed and 70%. They have also prepared appeal. And 30% liability fixed on me. We are also filed appeal, my lord. That was challenged.
To deposit the 30%.
30%. That is
Pure liability.
30% is there. And that 50%, 20 lakh, my lord, in so for 30%, lord, 23 lakh 20,200 is there. And that 50% I will deposit here itself.
US is only 30%.
Yes.
Then let you deposit that 30%.
Yes.
Whatever the share comes, 30%. Affidavit accompanied to the IA number 1 of 25. For the reason assigned in the affidavit, the operation and execution of the implement award passed in MUC number 1148 of 2021, dated 23/11/2024 by the Principal Senior Civil Judge and MACT Kalaburagi is hereby stayed in respect of appellant's share.
Please.
Appellant's share of compensation, that is appellant's 30% share, 30% share, subject to the condition that appellant shall deposit the his share, that is 30% of the compensation awarded by the tribunal.
Before this.
Before this court, within 4 weeks.
Please.
From today. Upon such deposit, the claimants, that is respond number, claimants, respond number 1 and 3 are?
Please, my lord.
Claimants are in
Lord, claimants, my lord, respond number 1 and 2. But here challenging liability is there, my lord, that cannot be, my lord, withdrawn. There is no coverage. At the time of accident, my lord, policy was expired. So for my lord, respond number 4 concern.
Notice.
If Kotokia is there, my lord, that is a Preeti Patil, madam.
Yes. Srimati Preeti Patil Velkondi is directed to accept notice to respond number 4. What about other respondent? Issue notice to respond number 1,
2, 3 and 5.
1, 2, 3 and 5.
Please.
Yes. Registry is directed to secure the TCM.
Lord, serial number 34 also connected matter arising same accident.
34 also same order.
And that, my lord, respond number 5 is, my lord, Ifko Tokyo, my lord.
Preeti Patil Velkondi is directed to accept notice R5. R1 to 4 issue notice,
Please.
Issue notice to respond number 1 to 4.
And 6 also.
6. 4 and 6. Same order.
Lord, here only challenging quantum. Lord, I will file memo for dispensation. My lord, I will deposit 50%. That may be it.
Full matter. Quantum alone, full matter.
Full
Quantum.
50%.
Full madi.
Please.
Quantum. same accord, there is full, subject to the condition that the entire compensation amount before the tribunal within 4 weeks. Upon such a deposit, the claimants, respondent claimants are entitled to withdraw.
50%.
ಏನಕ್ಕೆ 50%? ಆಯ್ತು 50% of the compensation.
One submission.
ಹಾ.
Respondent number 2, 3 and 4 are the minors. Respondent number 1 and 4, 5 are the wife and mother. Our share 50%.
As per the apportionment.
Apportionment ಅಂದ್ರೆ it will come slow. Minus amount will be deposited, my lordship.
That week. As per the apportionment of MUC.
It is 75% amount to be released as per apportionment ಮಾಡಿ sir. 75% amount to be released as per apportionment ಮಾಡಿ sir.
No, you can withdraw whatever condition.
Okay, madam. 75, 100%. They are minors.
ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟು ಅಂತ
Please.
50% as per apportionment as by the quantum as per quantum may pass by the tribunal. ಡೆಪಾಸಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದಾರಲ್ಲ ಎಷ್ಟೆಷ್ಟು ಅದೇ ಡೆಪಾಸಿಟ್ ಅಂಡ್ ಕ್ವಾಂಟಮ್ ಅಲ್ಲೇ ಹೇಳಿದಾರಲ್ವಾ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಂಡ್ ಡೆಪಾಸಿಟ್ ಏನ್ ಮಾಡಬೇಕು ಅಂತ ಆಸ್ ಪರ್ ಎಂಎಸ್ ಕೋಡ್. Yes. ಯಾರೆಲ್ಲ ಮೈನರ್ ಅದು?
2 to 4. 2 to 4. Respondent number 2 to 4 are minors.
Respondent number 2 to 4 are filed necessary application to appoint a guardian.
You have to file.
Please.
Insofar as minors, you have to file an application for appointment of guardian for respondent number.
Appellant number 1 is the guardian of the respondent number. 2 to 4 is a mother, natural mother.
No, correct. That you have to do it by appointment of application. Cannot be done by merely. Yes.
Yes. Please memo on reliance. The notice to respond number 6 is dispensed at the risk of appellant. Notice is ಯಾರಿಗಾದ್ರು ಯಾರಿಗೆ notice ಇದೆ? ಆಯ್ತಾ ಅಷ್ಟೇ ಅಲ್ವಾ? 1 to 5.
Respondent number 6 I will find memo for this.
ಮೆಮೊ ಹಾಕಿ ಅಷ್ಟೇ ಅಲ್ವಾ? 1 to 5 ನೀವು 6.
Our appear. But here also quantum malad I will deposit 50%. Liability questioning liability is also there. No DL. AN recovery is there. 50% I will deposit malad.
Regarding DL malad, already honorable tribunal has held malad under section 181. There is no any. That is
50% withdraw.
Please malad.
50% withdraw.
Please malad.
Notice to
malad.
Issue notice to R2 or
R2 malad.
R2 or
R1 I already appeared.
Appear.
Notice to R. Registry is directed to the TCR.
Passed over we can take at 2:30. Passed over at 2:30.